Translated.
My Lady, my Lords, just before the luncheon adjournment, I said I would look at the judgments from the US and Indian Supreme Court that the Supreme Court of Mauritius found it instructive to look at. And the US judgment is the Brown v. Hartledge case, which is at page 2601 of the bundle. Please. The facts of this case can be stated shortly. A candidate for a role as Commissioner of Jefferson County said in a televised press conference that if he were elected, he wouldn't take his full salary and would indeed seek to reduce the salaries of commissioners generally. And after he was elected, his opponent sought to challenge the election under the Kentucky Corrupt Practices Act. And the judgment is concerned with construing the provision of the Kentucky Corrupt Practices Act as against the First Amendment to the Constitution and how the two should be balanced. And it's for this reason that it is helpful and instructive in this case. The holding on page 2601 starts by acknowledging that there is a legitimate state interest in restricting free speech in the context of elections, but it requires a compelling justification, and it mustn't unnecessarily circumscribe freedom of expression. And what they found in this case is set out in this second part of the holding. The petitioner's statements, which were made openly and were subject to the criticism of his political opponent and to the scrutiny of the voters, were very different in character from corrupting private agreements and solicitations historically recognised as unprotected by the First Amendment. There is no constitutional basis upon which his pledge to reduce his salary may be equated with a candidate's promise to pay voters privately for their support from his own pocketbook. A candidate's promise to confer some ultimate benefit on the voter, qua taxpayer, citizen, or member of the general public, does not lie beyond the pale of First Amendment protection. If we go, please, into the judgment on page 2608, is the start of the analysis. And under the Roman numeral 2, the Supreme Court begins by acknowledging that states do have a legitimate interest in preserving the integrity of their electoral processes. And then it refers to, at the core of the First Amendment, a certain basic conceptions about the manner in which political discussion in a representative democracy should proceed. And it quotes the Milton, Alabama case, that there is practically universal agreement that a major purpose of that amendment was to protect the free discussion of governmental affairs. And this, of course, includes discussions of candidates, structures and forms of government, the manner in which government is operated or should be operated, and all such matters relating to political processes. And then the Supreme Court goes on to say the free exchange of ideas provides special vitality to the process traditionally at the heart of American constitutional democracy, the political campaign. And quoting from the Monitor Patriot case, it says, it can hardly be doubted that the constitutional guarantee has its fullest and most urgent application precisely to the conduct of campaigns for political office. And then we have a somewhat lengthy quote from that judgment about the candidate and the right of the candidate under the First Amendment to engage in the discussion of public issues and vigorously and tirelessly to advocate his own election and the election of other candidates. Indeed, it is of particular importance that candidates have the unfettered opportunity to make their views known so that the electorate may intelligently evaluate the candidate's personal qualities and their positions on vital public issues before choosing among them on election day. And so what the court says is when a state seeks to restrict directly the offer of ideas by a candidate to the voters, the First Amendment surely requires that the restriction be demonstrably supported by not only a legitimate state interest, but a compelling one, and that the restriction operate without unnecessarily circumscribing protected expression. And going to the bottom of page 2610, please, my lords, the court acknowledges that states may prohibit a candidate from buying votes. No body politic worthy of being called a democracy entrusts the selection of leaders to a process of auction or barter, and as a state may prohibit the giving of money or other things of value to a voter in exchange for his support, it may also declare unlawful an agreement embodying the intention to make such an exchange. And then further on down the start of the second paragraph on page 2611, says it's plain that some kinds of promises made by a candidate to voters and some kinds of promises elicited by voters from candidates may be declared illegal without constitutional difficulty. It is equally plain that there are constitutional limits on the state's power to prohibit candidates from making promises in the course of an election campaign. Some promises are universally acknowledged as legitimate, indeed indispensable to decision-making in a democracy. And then at the bottom of that page, candidate commitments enhance the accountability of government officials to the people whom they represent and assist the voters in predicting the effect of their vote. The fact that some voters may find their self-interest reflected in a candidate's commitment does not place that commitment beyond the reach of the First Amendment. At the end of that paragraph, my lords, so long as the hoped for personal benefit is to be achieved through the normal processes of government and not through some private arrangement, it has always been and remains a reputable basis upon which to cast one's ballot. And then there's an important passage which goes to my lord's question about the criteria by which one distinguishes genuine corrupt practices from legitimate campaigning. And it says it remains to determine the standards by which we might distinguish between those private arrangements that are inconsistent with democratic government and those candidate assurances that promote the representative foundation of our political system. We hesitate before attempting to formulate some test of constitutional legitimacy. The precise nature of the promise, the conditions upon which it is given, the circumstances under which it is made, the size of the audience, the nature and size of the group to be benefited, all might in some instant and to various extents bear upon the constitutional assessment, but acknowledging the difficulty of rendering a concise formulation or recognizing the possibility of borderline cases does not disable us from identifying cases far from any troublesome border. And then, in a sense, the factual findings that led the court to its conclusion. It's clear that the statements of Petitioner Brown in the course of the press conferences were very different in character from the corrupting agreements and solicitations historically recognised as unprotected by the First Amendment. His commitment to serve at a reduced salary was made openly, subject to the comments and criticism of his political opponent and to the scrutiny of the voters. We think the fact that the statement was made in full view of the electorate offers a strong indication that the statement contained nothing fundamentally at odds with our shared political ethic. And then over on the following page, 2614, please, fourth line down, not only was the source of the promised benefit the public fisc, but that benefit was to extend beyond those voters who cast their ballots for Brown to all taxpayers and citizens. Even if Brown's commitment could in some sense have been deemed an offer, it scarcely contemplated a particularised acceptance of a quid pro quo arrangement. It was honoured. It was to be honoured if elected. It was conditional not on any particular vote or votes, but entirely on the majority's vote. In sum, Brown did not offer some private payment or donation in exchange for voter support. Brown's statement can only be construed as an expression of his intention to exercise public power in a manner that he believed might be acceptable to some class of citizens. So that's the reasoning of the US Supreme Court, and as we will see, it was highly influential in the judgment of the Supreme Court of Mauritius. The next case in the bundle is the Balaji v. Tamil Nadu case from the Indian Supreme Court. I can take it quite briefly. Really, the key passage for present purposes is that at page 2654, Essentially, what happened in this case was that various promises were made by political parties offering people freebies, such as colour TVs, and they were made in the election manifestos of various parties. The Supreme Court of India held that these were not corrupt practices, but nonetheless that to avoid a sort of an arms race between the parties of offering different freebies to electors, that the Electoral Commission should produce a code of conduct for the content of manifestos. So that's where the court landed. But page 2654, please, my lords, briefly contains the key passage, paragraph 61.2, which I'll just invite my lords to read. My lady, my lords, freedom of expression. Now, although this is not expressly addressed in the judgment of the Supreme Court of Mauritius, the right to freedom of expression is a constitutional right in Mauritius. And if we please go to the authorities bundle at tab 1, we have the Constitution of Mauritius.
Could you give us the
electronic page is 1733 for Article 12. So, my lords, Article 12 of the Constitution, if one reads it through, seems faintly reminiscent of Article 10 of the European Convention, and that's not a coincidence. It was based on it. It has the same familiar two-part structure, with the Part 1 setting out the right and the scope of the right, and the Part 2 setting out the permissible restrictions. Article 12 is not expressly referenced in the judgment, but the court does make repeated references to the importance of freedom of expression in election time, and in my submission, it is an important factor to bear in mind in this case that there was a constitutional right engaged, because when interpreting Section 64, the court must, of course, have regard to the construction being placed that doesn't impinge in a disproportionate way on the constitutional right. That the respondents' right to freedom of expression was engaged by their campaigning is, in a sense, so obvious as to be stating, for the reasons set out by the Supreme Court of the United States in the Brown and Hartledge case. Election campaigning, indeed, is the paradigm case, we would say, in a democracy, of a situation where freedom of expression is essential. How else are the public to vote on an informed basis, if not by hearing from candidates for office about the policies their parties would enact if elected into government? And the second point that we would make, again, in a sense obvious from the facts, but The sorts of issues with which this case is concerned are core political concerns. These are policies on the level of the state pension, on the salaries of public sector workers, performance bonuses for certain classes of public sector workers, such as firemen and police officers. One can see that if any policy conferring a financial benefit on a certain class of voters were off limits, mainstream political debate as we know it would be completely undermined. One of the ironies of the appellant's construction of Section 64 is that it's only if there is a financial benefit that on their reading it is bribery. So in the applied to the election context, it would be possible to campaign for it wouldn't be possible to campaign for lower taxes and higher benefits because they do confer a financial benefit, but it would be possible to campaign for higher taxes and lower benefits because they don't. I mean, that's plainly an absurdity. Now, the Supreme Court gave a very careful and well-reasoned judgment after hearing evidence for nearly a month in July 2021. And the findings in the judgment as to why, on the facts, they found this was plainly election campaigning and not bribery are central. So I'm just going to take my lords through them before trying to address my lord's question as to what criteria can we take from the case generally. If we please start at page 421, which concerns the court's findings on the basic retirement pension. It's at the final paragraph of that page, and one can see, reading it through, the reasons why the court found that it was a campaigning promise and not bribery, made openly in public to a crowd from all corners of Mauritius, not a covert announcement by an individual candidate, but a proposal of a political alliance and an manifesto, not a decision, but a proposal of an eventual future government. It would apply to all old age pensioners of Mauritius, not just of constituency number 8. It would apply whether they had voted or not for the respondents or their alliance, and whether they had voted in constituency number 8 or not. For the following page, my lords, the fact that those announcements were made openly and in public and contained in a manifesto meant they were subject to the comment, debate and criticism of the public and political opponents and the scrutiny of the voters. And the court points out that the voters were presented with a choice. Both parties were offering similar policies, and it was up to them to decide. The second paragraph down, please, on page 422, the factors that the court identifies are the announcements were not the promise of an individual candidate directly linked to his own election, irrespective of the question whether his party formed a government or not. There was no quid pro quo or private arrangements between the respondents and the voters of constituency number 8, whereby the latter would have obtained an increase in BRP only if they voted in return of the former. There was no element of bargaining. And the conclusion at the bottom of page 422, this was an electoral promise contained in an election manifesto and made in the course of normal election campaigning. It was no more, no less than a statement of intention of a future eventual government. So those were the findings in relation to the BRP. The findings in relation to the PRB report are at page 427, please.
Sorry, page?
Page 427, please, my lord. And this is on the final paragraph starting in the case of both alliances. And the proposals relating to the PRB were contained in their electoral manifestos and made openly in public, addressed to the whole of Mauritius, not just constituency number 8. There would be measures applying to public officers residing in the whole of Mauritius, not just constituency number 8. There were promises of a future government. And then in the second paragraph, again, there was no evidence of any quid pro quo or private arrangement. In the third paragraph, these were not covert announcements by individual candidates, but proposals of political alliances contained in electoral manifestos. They were not promises of individual candidates directly linked to their own election, irrespective of the question whether their party or alliance formed a government or not. no element of bargaining. And then similar reasoning in relation to the performance bonus, and that's on page 429 in the paragraph starting as regards the payment of a performance bonus to police officers, firemen and prison officers. They point out this was a recommendation of the PRB report in 2016. It wasn't a new proposal, it was a question of when it would be implemented. It was, and they set out some of the context for that. And then they say at the bottom of the page, it is noteworthy that payment was effected to all officers concerned, irrespective of whether or not they had voted for the respondents in constituency number 8. It was not a misleading, false or unrealisable proposal. It is also noteworthy that the election manifesto of Alliance Nationale contained a similar proposal.
Do you say that the Supreme Court were applying Section 64? They weren't saying that ordinary, normal election proposals fell outside Section 64, but rather they were going through why the inference that it was to induce the electors to vote in a corrupt sense was incorrect. Which do you say it is?
Well, it isn't entirely clear from the judgment which approach the court is adopting.
Which approach is the correct one?
Well, in my submission, ordinary election proposals are out with the scope of Section 64. That's not uniquely by reference to the corrupt purpose point, but one has to look at all the factual circumstances in order to make the assessment of whether this properly falls within the scope of the section or whether it doesn't. And which brings me back to my Lord's earlier question, which is the factors that weighed with the Supreme Court as to why the respondent statements in this particular election were not bribery, but were in fact normal election campaigning, are in our submission unassailable, and this is what they were. Firstly, these were not the proposals of an individual candidate, but the proposals of an individual candidate on behalf of his or her party. Secondly, they were not directed at an individual candidate's constituency to advance his or her prospects of re-election in that constituency, but to the public at large in relation to the election of that party to government. Thirdly, they didn't involve any payment of money or promise to pay money to the respondents' constituents in return for their votes. They were policies which would confer a financial benefit on everyone who fell within the relevant group of electors across the whole country, regardless of whether or not they voted for the respondents. In other words, a fireman in constituency number 15 who voted for the opposition would be just as much the beneficiary of the performance bonus if the Alliance Nationale were elected to government as a fireman in constituency number 8. These were not done covertly, my lords. They were done openly as part of the normal campaigning process. They were done through, the policies were enunciated at public events, they were announced in the media, and they formed part of the manifestos of these parties. They were therefore subject to normal democratic debate and scrutiny. Furthermore, the promises were conditional. They were conditional on the party being elected to government and successfully enacting their proposals. They were, to use the phrase used in the Balaji v Tamil Nadu case, the promises of a future government. And my lords, the fact that the Alliance Nationale had similar policies of its own is of course not determinative, but it does serve rather to underline that this was all part and parcel of a normal election campaign, and what both parties were doing were putting their policy platforms before the electorate and asking them to choose. And in our submission, this case doesn't at all turn on distinctions between individual candidates and parties, or these sort of formalistic and unreal distinctions. An individual candidate in an election campaign is both an individual candidate standing in that constituency and a representative of their party, advocating the policy platform of their party. The policy platform of a party doesn't matter whether it's in a manifesto or whether it's in a speech. Doesn't matter when the speech takes place. It doesn't matter when the manifesto comes out. These are all part of the freedom of expression involved in the political process, whereby parties put forward their platforms to the electorate with a view to being elected to government. Now, my lady, my lords, this brings me to the question of statutory interpretation.
So just going back to that last submission,
yes,
it may help if it's in a manifesto, but you mean it's not determinative if it's not.
Exactly.
Right.
Exactly. So the Supreme Court here placed weight on the fact that these were in the manifestos because that indicated they were really important policies. Each of these policies of which complaint was made was one of the 15 key measures which this party was promising to the electorate if it were to form a government. But these are just different ways that different forms that political promises can take. Political promise can be part of a campaign made orally through an interview in the media, or it can be formally set out in a written document. They're all part and parcel of the same essential process in our submission. My lords, now the way this case has been put on appeal has raised some new issues that don't appear to have featured in any significant way before the court below. And the way that the case is now put, as I understand it, is that the court is compelled to reach the conclusion that this election campaigning was bribery as a matter of statutory interpretation. And it is said, for example, that full effect to the plain meaning of the words should be given and subtle distinctions should not be raised. We don't believe we are raising any subtle distinctions here. We believe that when one looks objectively at the facts as found by the Supreme Court of Mauritius, this case could only ever go one way, and it was always going to be ordinary election campaigning and not bribery. But as in terms of the point on statutory interpretation, our primary submission, of course, is that on the ordinary and natural meaning of the relevant words, election campaigning is not bribery. And my lords will have my submission in relation to that. But we say the position becomes even clearer if one adopts the approach to statutory interpretation that has regard to the context and purpose of the legislation, adopting the approach of the Supreme Court in the Coastal UK and Dunkley case, which is in my lord's bundle at 2202. Paragraph 30 of that judgment sets out the test.
Sorry, paragraph?
Paragraph 30 in the judgment of Lord Legate, my lord. The next heading of my note is free and fair elections, and we say that stepping back from the detail of this case, the context and purpose of the Representation of the People Act is to secure free and fair elections. The purpose of the provisions prohibiting corrupt practices is to secure a fair election by ensuring that voters exercise their free will and are not corrupted by payments of money or other improper inducements. And these provisions seek to safeguard the integrity of the political process. That's what they're there to do. But equally important is the need to secure a free election by enabling candidates standing for public office to campaign freely and to advocate the policies of their parties so that the electorate can vote on an informed basis. And in our submission, the correct interpretation of Section 64 must give effect to both of these imperatives, fairness and freedom. And this reflects the status of Mauritius as a constitutional democracy. which is reflected in Article 1 of the Constitution. And my lords, if my lords could pick up the authorities bundle very briefly, I reference this it's on page 1732, where it's the Article 1 of the Constitution is Mauritius shall be a sovereign democratic state, which shall be known as the Republic of Mauritius.
Sorry, I missed the page number.
I'm sorry, my lord, it's 1732.
Thank you.
And the Valet v. Rangoon case in this context is quite interesting, and that's, please, at page 2533, my lord, in the same bundle. 2533. And I'm referencing this case because this is a case where the Supreme Court of Mauritius had to consider the constitutional implications of a clash between a legislative provision and this Article 1 of the Constitution. And time doesn't permit me to go into it in great detail, but I don't think I need to for these purposes, because it's really page 2545, please, where the crucial reasoning is set out. And I would just invite my lords to read the first paragraph of that page, please, starting from, apart from those particular instances of a reference to a democratic society. So what the Supreme Court of Mauritius is holding here is that in the event that there is a clash between a statutory provision and Article 1 of the Constitution, the principle of a democratic state, the statute would have to yield. That's the conclusion the court is drawing there. And over the following page, my lords, there's an interesting passage starting at the top of page 2546, where it says, there can be no doubt that our constitution makers, by embodying in it much of the constitutional practice and principles of the United Kingdom, aimed at giving Mauritius a democratic form of government closely akin to that enjoyed by the British people. And then it says, there can equally be no doubt that by incorporating most of the fundamental rights and freedoms of the individual, guaranteed by the ECHR, it introduced into the Constitution, as an integral part of it, to the undertaking to respect the fundamental principles of democracy. And then there's a reference to Article 3 of the first protocol of the Convention, which is the right to free and fair elections, as my lords will all well know. And they say that fundamental principle is that the people of a country should have the opportunity to elect representatives of their choice to govern them by means of periodical elections. This is the principle of free and fair elections. Article 1 of the Constitution and the way the Constitution is structured reflect that, and indeed the Representation of the People Act is designed to secure free and fair elections. And this is reflected in the Electoral Supervisory Commission's Code of Conduct for the National Assembly elections in 2019, which was in operation at the time of this campaign. And that's at page 2556, please, of the authorities bundle. And I'll turn this up briefly because I'm conscious of the time. Page 2558, please, my lords. You can see that the Code of Conduct aims at complementing the legal provisions in force regarding the holding and conduct of elections in Mauritius, most specifically, especially those provisions relating to bribery and treating and the other illegal practices. And it says that the objective is to ensure the integrity of the electoral process and to enable elections to take place freely and fairly in an atmosphere of respect and tolerance conducive to free campaigning, unrestricted but responsible public debate, so that the electorate can make an informed choice. And then on page 2560, please, you can see that there are various principles set out, one of which is refusing to indulge in bribery and corruption, and the other is, at D, the right and freedom to hold meetings and to campaign freely within the limits provided by law. And then on page 2561, all participants acknowledge, confirm and proclaim that during campaigning each one shall have the right to unrestricted political activities within the limits of the law and to freely express his political beliefs and opinions, manifest publicly his electoral programme and his lines of action and canvass support for the same, organise and convene meetings and gatherings and rallies to advocate his ideas and advance his programmes. So there's a recognition, and obviously I don't place inordinate weight on what is really simply a code of conduct, but it's a recognition of the point that it's a recognition that both fairness and freedom have to have full expression for an election, a free and fair election to take place, and for the election to be conducted properly. So in our submission, when interpreting section 64 of the Representation of the People Act 1958, the court of course looks first to the ordinary and natural meaning of the words, but will also apply them having regard to the context and legislative purpose, which is the maintenance of free and fair elections, one of the prime objectives of the Constitution, as well as the right to freedom of expression. Now, my lords, there are further principles of statutory interpretation that could be invoked. Avoiding a construction that produces an absurd result would be one of them, and that's the McCool case, which is in the authorities bundle at page 2300, paragraph 24. Equally, the principle of doubtful penalisation referenced in the Tamil Nadu case, the Indian Supreme Court case, and also in the Good Law Project judgment in my Lord's Authorities bundle at 2274, paragraph 34. But it may be that with the ordinary and natural meaning and the purpose of construction, the court reaches a point where it doesn't find it necessary to have recourse to those further principles. My Lords, my submission is simply this. All of these principles point towards a construction that enables the court properly to penalise genuinely corrupt practices that do imperil the fairness of elections, while also protecting the freedom of expression of candidates for public office and the free election campaigning, which is indeed the hallmark of a free as well as fair election. My Lords, that brings me to the allegation of treating, which I can deal with quite shortly. The relevant legislative provision is section 64.2, and it is at tab 3. We have the page 1762. And when one looks at this provision, the thing that immediately jumps out is that the word corrupt appears twice in it. And what it requires is that the candidate has to be acting corruptly in paying for food, drink, or entertainment. And then this has to be done for the purpose of corruptly influencing another person to vote or refrain from voting. And this has been held to mean that the statute requires not only an intention to treat corruptly, but indeed that a voter has actually been corrupted by the treating in the manner in which they voted. And the reference for that, my Lords, is the Showfields at page 2581, and one gets a similar reference from a different part of Showfields at page 2546. But that point is well established and was applied in the Earlman
Sorry, the second reference was?
Sorry, my Lord, it is 2546. And that... So, my Lord, regrettably, this ground is simply no more than an impermissible attempt to challenge the findings of fact of the court below, without having identified any legal error on the part of that court that could justify such an exceptional course. And if we could please go to the judgment, finally, to look at the findings of fact the Supreme Court made in relation to the treating allegation. They start at page 445, please. And it's the second paragraph on that page, my lords. It points out that the event held at this conference centre on the 1st of October 2019 was to celebrate the International Day of Older Persons. And the allegation was being made that it was being done in a spectacular manner with the food and drinks being served. And indeed, the complaint was not that food was being provided. It was that the food that was being provided was said to be radically different from previous years. In fact, this year it was a biryani curry. And what the court points out is that since the year 2007, the International Day of Older Persons has been celebrated annually in Mauritius at national level, with transport, food and drinks being provided. The chief guest is often the President or the Prime Minister. There was therefore nothing surprising or untoward with the event held at the conference centre on the 1st of October, the distribution of food at the event, and the attendance of the respondent number one as Prime Minister and chief guest, as he'd been doing regularly since 2017. They pointed out in the following paragraph that it was the Ministry of Social Security which was in charge of organising the event every year, and that it always provides transport, food and drinks to the old age pensioners attending. Final paragraph, it points out that the Ministry of Social Security didn't form part of the ministerial portfolio of any of the respondents at the material time, and there's no evidence whatsoever that they had any influence in or involvement in choice about food and the distribution of food at the event. And then on the following page, second paragraph down, it deals with the suggestion that biryani was a radically different type of food from the other years. And it turned out that, having looked back in time, the biryani had in fact been served on the 1st of October 2014 at an event organised at the same event when the petitioner himself was a minister in government. So the court reaches the conclusion, perhaps unsurprising conclusion, that there was no evidence to show that the distribution of biryani persuaded or influenced any old age pensioner to vote for the respondents or to refrain from voting, and that indeed the voting took place 1 month after the 1 month after the event in question. My lady, my lords, it might be thought a surprising state of affairs that the outcome of an election and the destiny of a country should turn on the quality of a particular curry. But happily, such considerations need not detain your lordships, as the factual findings of the court below are indeed fatal to this ground. My lady, my lords, unless you have any further questions, those are my submissions.
Thank you, Mr. Fassel-Adams. We're very grateful to you. Thank you. Ms. Mountfield.
My lady, my lords, my clients are Mr. Rahman, the Electoral Commissioner of Mauritius, and Mrs. Gayan Galman Singh, who was the returning officer in constituency number 8. And they are people who are conventionally named as respondents in election petitions in Mauritius. No criticism is made of their conduct in the election, and they played no part in the factual inquiry of the court below. As Mr. Fassel-Adams observed, Article 1 of the Constitution establishes that Mauritius is a sovereign democracy, and the parties have set out in some detail in their written cases some of the machinery for the conduct of elections in such a democracy. The Electoral Commissioner's Office is provided for in sections 40 and 41(2) of the Constitution, which you can find in the bundle, page 1738, and in the regulations made thereunder. And the Electoral Commissioner is a public officer appointed by the Judicial and Legal Services Commission, qualified barrister, subject to no direction or control by anyone else, and he has such functions as may be prescribed in legislation made under the Representation of the People Act by the President of Mauritius. A full set of the regulations has now been placed in the bundle, I hope, or will shortly be placed in the bundle from page 2678 onward. And the precise detail of them doesn't matter here. Nothing turns on it, it's there for information. But it does establish that these are non-partisan players in the arrangement and conduct of free and fair elections as provided for under the Constitution. And it is their function and role to uphold the principles which support a democracy governed by the rule of law, and particularly those elements which underpin free and fair elections. And it is also important and material to this case that Article 12 of the Constitution, at page 1733, provides a constitutional right to the freedom to receive and impart ideas, as you would expect in such a democratic society. So it's elemental to a functional democracy, as envisaged by the Constitution of Mauritius, that an election is a free and informed choice between different policy platforms and is not corrupted by individual votes being bought. But two things follow from that. The first is that elections should be fought on issues and policy prospectuses and not corrupted by individual improper material inducements for electors to vote for an individual candidate. But the second is that there should be a free and open exchange of political ideas within that fair and open constitutional framework. And so laws should protect an interchange of ideas about desirable or undesirable political and social changes, including and perhaps especially at around the time of an election, so that the electorate can properly evaluate the positions of the parties on vital public issues before choosing between them. This appeal concerns whether the Supreme Court of Mauritius took the correct approach in law in reaching its conclusion that there was no bribery or treating such as to corrupt the election of the first three respondents in that case. And the principles to which I've just referred, particularly in Articles 1 and 12 of the Constitution, are the context within which the relevant provisions of Section 64 of the Representation of the People Act should be interpreted. Mr. Vassell-Adams made reference to one set of observations on the relevance of context to statutory interpretation, observations of Lord Justice Leggett as he then was. But may I ask you, for your note, to also note the observations of Lord Justice Leggett in relation to that in an electoral context, or in relation to a referendum context in the Good Law Project case, paragraphs 33 to 34, pages 2274 of the bundle, page 2274 of the bundle, and at paragraph 74, 2285. In our written submissions, we have sought to assist the court by drawing attention to the principles which govern the concept of bribery, and by drawing some analogies with cases from other jurisdictions which may assist in articulating where the where the line is to be drawn between a proper political promise which informs the democratic process and an improper individual inducement to an individual to vote. And I won't repeat those written submissions. And we also drew the court's attention to analogies from different democracies, India and the United States, recognising that those are based on different statutory language and to an extent slightly different constitutional provisions. But nevertheless, they are both useful analogies because they grapple with the tension between the ideas which underpin laws intended to maintain the integrity of elections in a democratic society, and so they may therefore inform the context and the interpretation of the Mauritian provisions. So the tension is between the idea that an election in a democracy is a choice between publicly expressed offers to the electorate at large on the basis of a prospectus of actions and choices in the event of victory, where the penalty for a false promise is at the ballot box in the subsequent election, and the idea that an election should be that choice between ideas and policy programmes addressed to the electorate at large, not individual promises to individual voters of individual reward in return for their votes. You've been taken to the relevant observations in the Balaj and Tamil Nadu case, and also the Brown case. I could just mention one aspect of the Balaj case beyond the paragraph 54, which sets out the distinction in that case between a political manifesto promise as a statement of policy and an individual promise, because at first sight the Balaj case is slightly odd, that the references are to freebies and they're to things like computers and even gold thalis and other things. But if one looks at the factual finding at page 2632 in paragraph 2, you can see that the reason that television sets, it was being proposed, would be handed out to poor rural families was for their entertainment and instruction. And as part of the election campaign, people were going from door to door to find out who might be eligible, particularly in rural areas. So whether or not it's surprising that an election manifesto might be, we will give things to particular people, it was part of a political platform with a rationale behind it. And so those cases do highlight the way in which an offer to the public at large may be distinguished from an offer of a quid pro quo arrangement of an individual variety. And it is, in my submission, fundamental that there is a distinction between a promise which is to be honoured in return for voting or refraining from voting altogether, simply to the individual who votes or refrains from voting, and a promise or a commitment to be honoured if someone is elected and if their platform is capable of being honoured in those circumstances. What is proper and improper, given the balancing commitments in Articles 1 and 12 of the Constitution, does take colour from its context. And in this context, the issue was whether what was in play or were in play were normal electoral promises or which were permissible in a democracy, or in effect bribes which were not. And the court found that the promise was part of a political programme, openly made on behalf of a party at large, to the electorate at large, and dependent upon a government being elected, as distinct from a covert offer made on behalf of an individual candidate only to voters who voted for him, and in the nature of a personal consideration for that vote. Now, my client makes and made no submissions on the facts, and it therefore depends on the findings of fact made by the court. There may be some cases which are at the margin in the application of that test, but that was the issue of law on the test for bribery and indeed for treating, which the Supreme Court in this case sought to apply. And unless there are any questions, those are my submissions on behalf of the Electoral Commissioner.
Thank you very much,
And
Ms.
Returning
Benson.
Officer. Thank you.
Mr. Pearson.
Lords, my lady. The Electoral Supervisory Commission there are no complaints against it and no allegations. And as usual, in keeping with our neutral stand, we do not engage with facts. We try to assist if ever possible, and we do hope that we may try to do so today as well. Our role and function of our client, my lords, my lady, are set out in section 41.1 of the Constitution. I will not take you to the electronic bundle, but it is at page 1738 and 1739. And it simply says that there is general responsibility for and to shall supervise the registration of electors for the election of members of the Assembly and the conduct of elections of such members, and the Commission shall have such powers and other functions relating to such registration and such elections as may be prescribed. Now, there are very few prescriptions which have been made, which either mean that there is little power or more power. It's one of the two. But one of the matters that has been discussed earlier is about, for example, the code of conduct. After my client was requested to prepare a code of conduct, he did so, but it is entirely voluntary. There is no compulsion in signing that code of conduct. It is signed at the time the person comes for on the election day when he presents his candidature, but is entirely voluntary. And what about a breach? Probably can only be investigated by a court such as this one. I doubt whether the Electoral Supervisory Commission would have any powers more than that, as could have been seen, for example, in the case of a complaint. That is the manner in which the Commission moves. When there's a complaint, it addresses it, it gives recommendation, it asks the person who has breached the conduct to exercise more caution, and this is the best we can do in the absence of any further laws allowing sanctions to be taken. The manner in which the Commission functions has been approved in Valette and Ramgoolam, so in your lordships I wouldn't refer to it, and that was further approved by the Judicial Committee in Fakimia Ahmed and at page 2109 of the electronic bundle. One of the matters, for example, that the Commission may do, and it's a matter of public knowledge, is it's to write to other institutions to ask them at election time to suspend permits so that they not be granted until the election is over. These are the type of issues which we may deal with. But as I say, most of those matters are purely voluntary. Now, the Code, my lords, my lady, are a set of principles, duties and rights which apply to all participants. And they include the political parties, the alliances, the candidates, the agents, their sub-agents, the employees, the supporters or backers. It requires that participants abstain from resorting to any electoral promises which are untrue or are unrealizable. A promise by a candidate may be untrue and unrealizable, and therefore in breach of the code, but may actually not amount to bribery under section 64.1 of the ROPA. And the converse is true. A promise made in an election may be true and easily realizable, but amount to an act of bribery. The Supreme Court did refer on a number of occasions to the Code of Conduct. As I say, it is probably the only place where it may be actioned, and again, only in the light of section 64.1, not in the light of a direct breach of the code itself. Now, to the extent that the Supreme Court relied on the fact that the promise to pay a bonus to public officers, for example, which meant it was not an untrue and unreasonable promise, and indicated that the promise was not an act of bribery under section 64.1, the ESC is the respectful view that whether a general policy announcement prior to an election was carried out following the election is not a relevant factor in assessing whether the announcement fell within the scope or not of section 64.1 of the Representation of the People's Act. My Lords, my Lady are aware that the legislative history of Section 64(1) can be traced back to the Corrupt Practices Prevention Act 1854, which explains not only the similarity, but in fact the exact words being reproduced. The only difference is the word from every person to any person. And the Act was reproduced in Mauritius by a letters patent of 16th of September 1885. They are not in your Lordship's briefs, I'm sorry about that, but it included a Section 27, which Section 27 stated the following: the following persons shall be deemed guilty of bribery within the meaning of these letters patent, and then it follows, every person who directly or indirectly, by himself or by any other person, on his behalf, gives, lends, or agrees to give or lend, or offers, promises, or promises to procure, to endeavor to procure any money or valuable consideration to or for any voter, or to or for any person on behalf of any voter, or to or for any other person, in order to induce any voter to vote or refrain from voting, or corruptly does any such act as aforesaid on account of any such voter having voted or refrained from voting at any election. The point is, it is exactly what you have seen all along in Section 64(1). There's been remarkably very little change from those days until today, which is why the Commission respectfully invites your Lordships and your Ladyship to draw upon any English precedent it thinks may be of relevance. And the Section 67(1)(a) of the Legislative Council Ordinance of 1948, which is the precursor of the Section 64(1), is in the same words. And therefore, in our submissions, those words have remained almost unchanged since 1854. I will not read to your Lordships and your Ladyship Section 64(1). You have spent enough time on it, and neither in the manner in which it has been explained. What we would like simply to address, my Lords, my Lady, is that in the Holsbridges of England of 1932, we read the following: that corrupt practices and illegal practices are technical terms to denote particular offences defined by the Act of Parliament. That was, at the time, the Corrupt and Illegal Practice Prevention Act 1883 and the Corrupt Practices Prevention Act 1854. And the authors then state that bribery is a corrupt practice. Now, obviously, corruption extends to all types of practices, including bribery and cheating. It is simply one of the categories of corruption. As a matter of English law, we respectfully say bribery remained an offence at common law, notwithstanding the enactment of the 1854 law. The matter is quite different in Mauritius because the law was required in order to make it an electoral offence, as it did not exist. As your Ladyship and your Lordship would know previously, the French had different concepts, and there was the Legislative Council functioned quite separately. The definition of the term bribery under Section 64 of the Representation of the People's Act therefore must be construed through the lens of an election offence, which the legislator intended to prevent, is our respectful submission. And the mischief which the Act sought to prevent may be described, and we've taken it from Horsbury Laws of England, 1932 edition, at page 256. The policy and theory of the law is that every man upon whom the election franchise is conferred should judge for himself who is the best and preferable candidate and give his vote accordingly. There are some influences which are called due influences and other influences which are called undue influences. Among the latter are what are called bribery, cheating, and oppression, that is, undue improper pressure put upon a man. By the common law, bribery, cheating, and undue pressure vitiate an election. We have referred to...
Do we have the electronic page bundle for that?
I do not have it, my Lord. I regretfully, but I'll make sure that I may leave it with your clerk, a copy of the document afterwards. I do regret that. The next part also I do not have with me, which is simply what we wanted to take from Lissack and Horlick on bribery and corruption, the third edition, where we've read the following, which I think is of some interest. Corruption is a protean beast, and it can take innumerable forms. It is not easy to identify, even if one is looking for it. The many guises in which corrupt conduct may be clothed go some way to explaining why a general offence of corruption would inevitably be either too narrow to catch all its forms or too wide to retain any coherent sense or meaning. It is therefore not surprising that anti-corruption laws in England and Wales have developed over the centuries in a patchwork way, with specific offences and provisions targeting specific manifestations of corruption. My lords, my lady, we believe that this explains the cases, these 5 cases of the 19th century we have seen, and also the difficulties of expressing a test. There can be no such test. There may only be examples, inferences drawn. At some point we saw the word prima facie. I'm not too sure whether that would be a correct statement of the law today, but probably something that in French I can find the word déterminant, something that comes immediately to you, and afterwards there may be need for an explanation later. But it cannot be, it is probably inferences drawn from a set of circumstances, which is the best manner to explain it. In our respectful submission, the starting point of the analysis is therefore the textual interpretation of Section 64 of the Act, as it traces its origin back to the 1854 Act, as I've said earlier. And therefore, this is why we respectfully draw upon the English authorities. And the Commission believes that the act of corruption is spelled out in Section 64(1)A is that of giving money or money's consideration to induce someone to vote or not to vote. And our respectful submission, that act of bribery must carry with it the corrupt element, which is an inference from the objective facts which are observed. Can there be bribery without a corrupt element? That would be extremely doubtful, because Section 64(1)A emanates from the 1854 Act, as I said earlier, the very purpose of which was to prevent corrupt practices. The corrupt element, in our respectful submission, is to induce persons to vote or not to vote by provision of money or money's worth. And we refer, your lordships and your ladyship, to Lord Rogers' speech in Ringado and Jagnat at paragraph 42, which is to be found at page 2152. And your lordships will see there that Lord Roger would say that it is with the intention of inducing the Muslim voters in the audience to vote for his party, an inference that he draws, that the court draws from the surrounding circumstances. Mr. Justice Wise, in the House of Lords case of Cooper and Slade, the 1857 case, at page 1889, regarding the paid travel to Cambridge expenses, paid travel expenses to Cambridge, observed that the word corruptly in the statute, that was the 1854 Act, 1889, does not mean dishonestly, but means purposely doing an act which the law forbids as tending to corrupt voters. That is the 9th line from the top of the page. And he goes on at the end to say, the word corruptly seems to be used as a designation of the act of rewarding a man for having voted in a particular way as being corrupt, rather than as part of the definition of the offence. I agree with what was said by the learned judge at the trial, that if the moving of cause of giving money is the voter having voted for the particular candidate, such gift is contrary to the statute as being given by way of reward for the vote, and therefore corrupt. This may exclude cases in which money is given for purely charitable motives through a voter, when in the present case no other probable motive besides the vote upon the defendant's side itself appears or can be suggested. Again, my Lord, inferences drawn from the facts, which would then allow the court to make a view of the purpose for which the gift, money, the reward was given. The purposely doing of an act is if it is animated by a desire to achieve something which is improper, must be corrupt. And if a man does an improper thing, that is the influencing of vote, which must produce an effect on the election, then it must be contrary to the act in our respectful submission. And we refer, your lordships, to the Kingston and Hull case and the judgment of Mr. Justice Ridley at page 2172. There can be no fixed categories given, but probably pointers that may be used in order to inform what inferences one may draw from the facts. My learned friends on both sides have already covered issues of an act being overt or covert, the timing issues, in the case of treating, a one-off treating or a recurrence over a long period of time, or in the case of Limerick, when the treating happened 2 days before an election, the drinks were given, the audience targeted, how large it is. It is very difficult to be able to give a category. It is only pointers that may be offered to the court, and therefore, in our respectful submission, corruptly has not been defined by statute for that very reason. It has to be interpreted by the court on a case-by-case basis. It does not mean dishonestly, as was stated in the Harvey case, 1999 Criminal Law Reports at page 70. And the definition given in Cooper and Slade, although one which is important, may somewhere be circular when one reflects upon it. And one would probably be as best to look at the dictionary definition and the normal natural meaning of the word corrupt if one is to go any further. Lastly, a bribe may be innocently received by the recipient, but still be corruptly given. And we we haven't given it. Doesn't matter. So the points we wanted to make as our closing points are the following. That is, firstly, in the context of an election law, corruption would not require an element of dishonesty. It suffices that the persuasion, the prevailing upon the mind of the elector is attained, drawn from inference, and it does not require either immoral conduct. Instead, it is the intention to do the improper thing that will be the natural and reasonable inferable from the objective and outward acts of the parties. We use the word in our submissions of a question of fact and degree. We regret that we cannot find much more to say apart from that. And as the court observed in Wallingford, as will all questions of intention, you look and can only look at outward acts of the parties to find what is the intention. My Lords, my Lady, those are our submissions unless we have any further assistance. We'll provide the copies, my Lords, if that is possible later.
We're very grateful to Mr. Person. Thank you very much.
Thank you, my Lord.
Mr. Straker.
Much obliged, my Lord. I trust the committee won't worry if I say that I don't view it as any part of my task to ensure that the committee stays here until 4 o'clock. I no doubt could ensure that if I wanted to, but I trust that I don't, and I hope I will be forgiven if I don't. Can I start then with that which has just been said, just as a word, because it was very interesting to hear the source and origin being the English origin, the reference to the English legislation, the desire to take from the English cases, and the reference to how one should view and consider corrupt practice or illegal practice. And I just mentioned that in this context, of course, because it may be known to the committee that those are matters, as has just been said, of categorisation, because under the Representation of the People Act of 1983 in England, one can sometimes be excused for an illegal practice, but one can't be for a corrupt practice, a category in which bribery appears. In relation to treating, my learned friend drew the committee's attention to the menu on the day in question. I don't pay any regard to that at all, and I don't ask the committee to pay any regard to that at all. What I ask the committee to pay regard to, as far as treating is concerned, is the temporal point. The fact that the sequence was, as I mentioned this morning, October the 1st, October the 6th dissolution, and the election was coming in any event. And we saw, via the Kingston upon Hull case, electronic bundle 2171, there's no need for me to turn it up, that time is of critical importance, because what impression does it leave, whatever the food or drink consists of, the mass feeding of a carnival atmosphere when a political speech is made but days before dissolution occurs. And then one has the way in which the courts view that, and can view that as doing that which the legislation prohibits, so constituting corruption.
Mr. Strickland, you said that the election was coming in any event, but was there a finding to that effect?
Yes, because I say a finding because the previous Parliament had been elected in 2014, and it's a 5-year term, as it is in this country.
I see. Thank you.
What I can't immediately do, I'm afraid, off the top of my head, is say where that appears in the papers, but that, such is the case, is undoubted.
So does that mean that the dissolution of Parliament was in effect mandated by law?
That dissolution was not mandated by law in the sense that the Prime Minister waited a little bit longer, but it wasn't much longer that had to be waited.
And when was it until?
Oh, I think it was November that there would have had to have been a dissolution. Yes, I'm being told November.
Okay, thank you.
So it was a month or so.
And how about the word an election in prospect? How are people to understand what is in prospect? There are lots of times that elections are in prospect,
Well, yes.
and they don't in fact transpire.
That is undoubtedly true, and in the Kingston case, we can all remember how in 1910 there were the two, or I remember from the history books at least, how in 1910 there were the two elections, and no one quite knew that the second election was coming, which was in fact a repeat of the first. And in that Kingston upon Hull case, the judges say, well, it became apparent because the Constitutional Conference, which had been called by the King to try and resolve matters, collapsed and the election occurred. But election in prospect here is undoubted because of the 5-year point which has just been canvassed between me and my Lord Sales.
Just reflecting on that, going back to some of the submissions about speeches being made before the manifesto was published.
Yes.
It was obvious there was going to have to be a manifesto if there was going to have to be a general election, wasn't it?
Well, I suppose one can say it's obvious that there would be a manifesto if a party alliance emerged or came into being and produced a manifesto. But a manifesto is not, as a matter of law, something which is required. And that enables me, if I may, to step away from the point about treating to the question canvassed by my learned friends about the construction of Section 64 and bribery, because one aspect which was barely touched upon, though it was spoken to, was that of the individual candidate. But my learned friend said, well, the individual candidate would have a party label. Not so. That is completely not the case. Because in Mauritius, just as in this country, one can stand proudly as an independent without any party allegiance at all. And it is of the first importance, I respectfully say, that an individual candidate is treated in exactly the same way as the established candidate, and no returning officer worth his salt will do anything different from treat the established candidate the same way as the individual candidate, however extreme or odd or peculiar the individual candidate may appear to be. I should just add to my Lord Sales's point about timescale. In his speech at page 1360, the Prime Minister said, we have almost reached 5 years. Thank you. So that takes me, if I may, to the point as to the construction of Section 64. It's got to mean the same for everybody. It's got to mean the same for the independent candidate as it does for the party candidate. And the party candidate is only properly to be described as a party candidate in this sense, that the regulations that my learned friend Miss Mountfield referred to and has produced enable, and I think it's Regulation 12, I haven't got the page number to hand, and Document 6, the ballot paper, enable it to be put against the candidate's name, whatever the name of the party happens to be, and the party symbol. That's all. And so that the role of the candidate is still the vital and critical role, and it must mean the same, this section 64, for the man who has no party at all and the man who has a party, in the sense that I've just described. And it is said that there is an inhibition on the freedom of speech, or could be an inhibition on the freedom of speech, by approaching the section in the way that I invite the committee to approach this section. First of all, my invitation is to do no more than, which is quite a big task because it's a mighty long section, is to read the section through from beginning to end. And second, simply to construe the relevant words in a perfectly ordinary English sense. And that does not mean that I'm endeavouring to elide or move over or slide past any aspect of in order to induce any elector to vote, as my learned friend would have it. Far from it. That is part and parcel of the language which has been given. And in this case, we know, because the Supreme Court were kind enough to tell us, that this was done in order to induce electors to vote, because they've said this is part of ordinary electoral work. And ordinary electoral work, by definition, is in order to induce an elector to vote. So we then simply get to the language given by Section 64(1)(a), and I respectfully say there's nothing in it on a proper construction which inhibits the free exchange of political ideas. All it does is prohibit certain promises which are particularised in Section 64(1)(a) as far as we are concerned. And as far as that matter is concerned,
you could therefore stand for increasing taxes but not for decreasing taxes.
No, I wouldn't. put it in those terms with the greatest respect. I mean, one can stand for saying, I think the taxation burden should be lessened or the taxation burden should be enhanced. What one can't do is to say, whatever the target audience may be, it may be a small target audience that one's got in mind, or it may be a big target audience that one's got in mind, is to say to that target audience, look here, what I'm going to try and do is to get this solution to your particular problem, which is measurable in money terms, namely this, or I'm going to try and get this solution to your problem in terms of not having any work by procuring these offices which are in the gift of the state if I'm elected. And so I don't respectfully say that one can't say about tax burdens being higher or lower. One can do that. One's not inhibiting free political discourse in that way. One's simply stopping certain promises. And where my learned friends run into difficulty, my learned friend runs into difficulty, I respectfully say, is that one has no means properly to distinguish between what is characterized as the ordinary political promise or the political campaign point that ought to be made from that which is prohibited. And the only solution to that problem is to look at the words of 64(1)(a) and to seek to apply them. And it's a matter of regret, possibly, to say that my learned friend is not quite right when he says that come 1872 and the secret ballot, bribery ceased in this country. One can look through the books and see plenty more cases of bribery after 1872. Nor is he correct, and one only has to bear in mind that chapter in Pickwick Papers about Eton Swill, published in 1837, that there were many more ways than simply passing a sovereign coin or whatever it may have been to an elector in terms of bribery. So there are a multitude of aspects which were sought to be got at by the legislation which was in place. I've got two minor points just to mention by way of addition/correction. As far as inducement is concerned and the speech of October the 1st, there was in fact a contrast between what was stated, see the speech at 1360, with what went into the manifesto 1448 in terms of the particular numbers. And in terms of the question as to campaigning together, I'm not sure whether I gave the references before, but this is R2 and R3. It's page 989 and following. So that is effectively how I would respectfully respond to this matter, and it just goes back to saying to the committee, please look through section 64(1) and apply it. And the committee has the findings of fact by the court, which make plain what was going on, and if it is a promise to procure or to endeavour to procure valuable consideration, then I'm afraid that's it as far as the first respondent is concerned. Yes, I'm being reminded, but I think I've drawn attention to the proximity in time. The point which is being drawn to my attention is as follows, and it may have been picked up from the papers. There had been a budget in 2019 which dealt with the question of the pension. And so when the October speech comes to be made, it is most distinctly something which is new and consequently an electoral inducement because it was different from and a departure from the budget position which had been established in the summer of 2019. That was the point that was drawn to my attention. Yes. So, unless there's any other particular matter, there are 2 points which I would just wish to make, if I may, before I sit down, unless there's any particular query which is asked of me. The 2 points are as follows. First, this petition was, of course, filed as long ago as 2019, and we're now here 2023. We're very grateful for this committee expediting the hearing of this. It's no part of our position to, so to speak, say, please can you order your affairs in a particular way, but we hope that that can be borne in mind in thinking about when this judgment should be given. And the second point is connected with that, and it's this: can we please deal, and I think I speak for everybody here, with all questions of costs which arise in writing after the judgment of the committee has been given.
Thank you, Mr. Straker. We're grateful to you and to all counsel for your submissions in this matter. We're also very grateful to those sitting behind you who put in a great deal of work in the preparation of the papers for the appeal. The board will take time to consider its judgment. Court's now adjourned. Thank you very much.